Harvey Zarabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, time clock rounding in California. Time clock rounding refers to adjusting time clock entries to the nearest set increment. For example, if you clock in at 8:03 a.m., your time might be rounded back to 8 a.m. or forward to 8:05 a.m., depending on the rounding policy your employer has in place. California law allows time rounding only under very specific conditions. The rounding must be neutral and not to pay or compensate less than what is fair. Although the practice of adjusting time clock entries is common, it is often illegal, as employers most typically use it to save money by underpaying employees. Here are some examples of when a rounding policy is illegal. The rounding must not systematically undercompensate employees over a period. If the rounding policy consistently results in employees losing paid time for a significant fraction or majority of employees overtime, it is illegal. The policy must be facially neutral. This means that the policy cannot always disadvantage employees as it is written. Common examples are policies that only round in one direction. For example, always to benefit the company, or policies that penalize employees for clocking in late while not benefiting them from clocking in early. California wage and hour law provides greater protections than federal law. While federal law allows rounding employees' hours to calculate the number of hours worked, California law does not. In California, exact timekeeping is crucial for making certain that employees are compensated and paid for all hours they work, regardless of how minimal those times are. For instance, with respect to rounding employees' total work hours, California law requires that employers must ensure that all time worked by their employees, no matter how brief, is accurately recorded and compensated. For example, in institutions where exact timekeeping is possible, when your employer can and does capture the exact time you work down to the minute using the electronic timekeeping system, your employer must pay you for every minute you work. Your employer cannot justify not paying you for every minute worked by relying on a policy of rounding time. A few extra minutes of work each day can add up. In these types of scenarios, rounding down or shaving minutes off the actual hours that the employees worked violates California law. California law also set strict rules about the use of time rounding system with regards to meal periods. Employers in California cannot use rounding policies for employees' meal punches. This is because of California's meal break laws, which require employers to provide non-exempt employees with duty-free, uninterrupted, unpaid meal periods of at least 30 minutes if they work more than 5 hours in a day, and a second meal break if they work more than 10 hours in a day. Therefore, your employer can never round your time punches when you clock in and clock out for meal periods. Understanding time rounding practices and recognizing when they are illegal is important for ensuring fair compensation. Make sure you're paid for all the time you work. If you suspect that your employer's rounding policies are illegal, don't hesitate to contact an experienced California law attorney. Remember, your rights as an employee are protected by law, and you have the means to take action if your employer fails to comply with the regulations. So stay informed, know your rights, and advocate for fair treatment in the workplace. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notifications.